Just different in us that if you change slide patterns, it screws everything up, so we were guessing. Good morning, my name is Tom Blackwell. Larry Cohen, Larry and I are going to be talking to you today about what I think of as sort of the other facet of technology in law schools. And I'll try not to pace over here too much so the screen can see me. As my students will tell you, I am a bad pacer, so I'll try not to, but no promises. I see this as sort of the other angle of technology in law schools. Most of what we've been talking about here at the conference is focused on how to do the technology, how to make things work, or how to get the technology into the faculty's hands and get the faculty up to speed and get them to use the technology. What we're going to talk about now is sort of the rest of the equation, and that is how to get the technology in the hands of the students and what they're going to do with it once they leave law school. Okay? I have to introduce myself. Larry's at University of Michigan. I'm at Chicago Kent right now. Email address, I suppose this is all going to be posted up on the web afterwards, so if you need to get a hold of me, you can find me there. After August 1st, I'm not going to be at Kent anymore. I'm going to be at Appalachian School of Law, but I will still be as available there as I am in Kent. So, and actually, I think the Kent email address will work for a couple of months after I'm gone, forwarding stuff to me anyway. So that'll be a way to get hold of me. Okay. You'll have to put up with the annoying sounds. Okay, there may be extra bonus points later on if you can identify some of the sounds. I'm talking about, as I said before, technology for the students as opposed to technology for the faculty and administration. And to clarify that, and it may not have been entirely clear from the title of the talk, but I'm not really talking so much about technology for the students in law school, but talking about teaching the students about technology that they're going to be using out in practice. Okay? So this is more of a forward-looking thing. I'm already assuming that most of the students know how to use email within the law school and that they maybe have some basic word processing skills and maybe some other computer skills, but we're looking at sort of a forward-looking thing. I'm going to be specifically talking about a course that I taught last summer to a group of students and sort of the lessons that I've learned and things I would do differently and things that worked well. Larry is going to be focusing more on the far side of the mirror as to what happens in the practice and how much of this is going to be relevant when the students are actually out there. Also, to clarify what I'm talking about computer technology, not copiers. I don't think the students were real confused about that when I offered the class, but I did tell them, though, that they really should be sure that they know how to use copiers because they may be doing more of that and maybe making coffee than they will doing anything else once they actually get out into practice. Scanners. Scanners would be another good thing. We did bring some scanners into the class and show them how to use that as well. I'd forgotten that. My basic premise, though, was that law school graduates need to know how to use computer technology in their practice. Okay? And the question came up as to why is it that the lawyers have to do this? Most everybody in this room is going to be sold on this already. But just thinking back, and this is sort of the process that we went through, or I went through in justifying the course when we were setting it up. The lawyers do need to use this. We have a lot of students at Kent who are probably going to be going out and doing solo practice when they get out. And so this was really done with them in mind, but it's also done with the thought that the students who are going out to work in firms, large or small firms, are also going to have to use the technology because that's just what lawyers do. Okay? Hard sell to some of the practitioners some years back. It's, as Larry will say, I'm sure it's getting a little bit easier. Computers can alleviate drudgery for the lawyers, and it's no longer really seen as demeaning. When I was first starting out in practice, lawyers wouldn't have computers on their desks because that's what a secretary does. I'm not going to type. Okay, so the lawyers didn't want to do that. That stigma, I think, is not there so much. It is also true, though, that law firms whose attorneys are not computer literate are at a real significant disadvantage in terms of dealing with other lawyers out there. You just can't practice law without computers now. And finally, the clients do expect it.
Very bad feeling up here.
You hear that? Not quite loud enough. Trying to keep with the theme of the notes last night. A little bit. All right. Now, even if we accept my basic premise, which was that the students need to know this stuff once they get out. Can you hear me, Steve? Okay. If you go with the premise that they need to know it when they get out, the question then comes up is, well, why should the law schools teach this? Okay. It's just using computers. It's just typing. It's just whatever. You know, they can pick that up once they're out, and they already know how to use Word or WordPerfect, so why should we do anything? Well, what we found as we were talking with practitioners and firms that were out there was that law firms really do expect their new hires to have some technology background. They don't want to train them. They want these guys to be able to hit the ground running. Also, because we had such a large proportion of our students who were destined, based on what we'd seen before, to go out and hang out their own shingle and do a solo practice, they had nobody to train them. They needed to get that information somewhere, and law school is an obvious candidate for doing that. And even though it is possible to get some pinpoint training, okay, you can go to this Corel seminar and learn how to use WordPerfect when one of them comes through. There were very few of those type of post-law school educational experiences that we saw that gave an overview of using the technology in the practice. Okay, now when we're thinking about what goes into this type of course, and if you're thinking about implementing this type of course at your school, you got to think about what goes into the curriculum, what goes into the syllabus for this course. And you probably need to start with areas that the computers are actually used in law firms. Okay? And I'm just going to rip through this. Some of this you already know, some of this you can expect. Calendaring, personal information managers, groupware type programs, drafting at the keyboard, something that we all do, or most of us do now. The old paradigm, was using legal pads, writing it all out, and then people got really jazzy and they started dictating stuff. And I think now the move is for a lot of lawyers to be just drafting the stuff directly at the keyboards or touch. They need to know how to do that. One dream, this last one, of standardizing law firm documents and forms, I'll be honest, that I think is a myth. It's been a reason for doing computer-based stuff that I've heard bandied about for probably 15 years. And to my knowledge, even the law firms that have implemented firm-wide databases of forms and memos and information, they don't get used as much as the people who have been pushing them really say that they ought to be. So that one I don't know is that strong a reason for it. Electronic research, Lexis, Westlaw, CD-ROMs, we all know about that. Practice management software, email, document assembly, that's another one that's maybe not used as much as 10 years ago people were saying it was going to be used. Spreadsheets, lots and lots of use of spreadsheets now. They're useful tools. Of course, timekeeping and billing. And there's a real move on in practice to move that towards the individual attorney's desktop rather than having them fill out timesheets and give them to the secretary to type up. That's happening more and more as the firms are driving to try to capture all the time they can. Automated redlining programs, I love those. They're wonderful. I'll tell you about them later if somebody wants to ask about that. And document management for litigation stuff. Sound good. Those of you who can hear that, what is that? Nobody can. Mist. That's good. That's good. Okay, I wondered whether or not we'd get somebody to do that. Okay, the course was called Law Office Technology. It was offered at Chicago Kent last summer. There is a web page up. You can write that web page down. I will leave it up for a little bit. You can't see it? Oh, geez. Okay, it's ck.kentlaw, KENTLAW.edu/WCB/schools with an S /CK. It's a horribly long URL. That's a capital C, capital K, /law /TBLACKWE/index.html. And I apologize for the length of that URL. I didn't do it. It wasn't me. That was where I made me put my files. Okay? That website it's a Web Course in a Box web page. It's set up so that it should be available for public viewing. It should be up there for at least another month or two before they start really cleaning my stuff off the network there at Kent. It has a lot of links on the page there to materials that were used in the course, both in terms of readings and in terms of project assignments. So if you're thinking about doing this, you may want to look at it, download some of the files, and I'm making them freely available, what I've got out there. What I found, and I'll talk about this a little bit later, was there was not much in the way of materials that were easily available for this kind of course. So I'm glad to help folks out. Okay, coverage. What did we talk about? Well, first thing I started off by telling the students about what I saw as being current trends in hardware and software. Whatever those were a year ago, those have changed now. But at the time, what I saw. We talked about word processing and document automation. We talked about the impact of the internet. Doing it again now, I would probably stress that one even a little bit more. We talked about timekeeping and billing and integrated practice management. We talked about ethical issues related to technology and law office automation. Now, this was a big hot button for me. Okay? I was telling somebody earlier before the class started. When I was in practice, before I started teaching, I was a transactional lawyer. And my experience was that for most transactional lawyers, their working knowledge of professional ethics was lawyers are not supposed to represent more than one client at a trial. Okay, and that's all they remembered from their professional ethics class. And if you ask them anything beyond that, it was just gone. And so for years, I was doing a lot of continuing legal education seminars focusing on professional ethics issues for transaction lawyers and the problems that they had forgotten or maybe no one had ever told them in doing it. And I think a lot of those issues about client confidentiality and things like lawyer advertising and stuff come up in the technology area that need to be readdressed. So that was a big hot button for me and sort of an underlying theme all through the course. We talked about spreadsheets, but I'll be honest, I wound up cutting this out of the course because, much to my surprise, I discovered that almost every single one of the students that I had in the class were more comfortable working with spreadsheets than they were with word processors. And that really surprised me, but it may be some indication of that a lot of the student body at Kent are students who have previous careers and who are coming in. And they learn to do spreadsheets as jobs, but they didn't do much word processing. So I wound up sort of going light on that one. We did talk some about special purpose programs like PowerPoint and various other things that the redlining programs and that sort of thing. We went light on that. We did a lot of basic web page design stuff. What is HTML? HTML for dummies or for law students. We did not directly cover computer-assisted legal research. And that was conscious in part because it would have overlapped with an existing course. We had an advanced computer legal research class. It was a standalone class, so I didn't feel like the students needed to hear it again from me. And there wasn't enough time in the semester to really spend a lot of time working on that. I figured they could get that from other places. Some of these topics are appropriately covered in a larger course, a general course on law practice management. And in fact, my original thinking about this was as a piece of a law practice management course, skills course. To be honest, once I got into this and we started pulling out the material, it filled the whole semester. So you'd have to go fairly light on some of these issues in a larger course, or have a lot more than the 2 credits that we had allotted to. I mean, there's just a lot of stuff that were there. The volume made it difficult to even treat some of these things very well in the time that they had. The students were a little frustrated when I had to zip through a couple of things that they found interesting. What do you need? Setting. The setting for the class, it was held in a computer lab, sort of like the one right next door here. Okay? I limited the class size to 20 students and then took 2 more when I was pressed to do that. I would strongly advise you, if you were doing this, not to have more than about 20 students. Okay? This is a very different kind of class, or what I was doing from a typical law school class or even a seminar class. This is a training class. It was very, very hands-on. And for those of you who were in Hugh Gibbons' deal yesterday afternoon next door, where he was demonstrating some of his software, the kind of frustration that's involved for you as a teacher in those classes when you've got 20 people, and I guarantee there will be somebody in there who says, it didn't do that for me. I tried that. What did you click? What was that? And it's very difficult to get everybody to step through the stuff. And I tried to make the class a very hands-on class. We had it in the lab so that I could have the students pull up the software, and as I was talking about stuff and demonstrating it, they were doing it as we were going through the class. So typically I picked on one of my students, and I got them to sit at the keyboard that had the projector, and they got to demonstrate stuff, and everybody got to do it right in front of their face. The readings that I used for the class, as I mentioned, it was a little bit difficult for me to find material, so I was making stuff up as I went along. And given the time pressures of the class, between that fact and the fact that I taught it as a summer session class, which means we only had 8 weeks total, meant that I had to be able to get the information out to the students very, very quickly to get them at it. So the very first thing that they had to do, and this was actually difficult for a couple of students who were not real computer savvy, was they had to go to the web page for the class and pull the readings off to do that. So that I did assume some level of internet savvy that they had, and I had to help a couple of guys to get up to speed on that. The course was also a project-oriented course. Again, my philosophy was that you learn this type of stuff best by doing it. The way that you learn software well is by rolling up your sleeves and wading into it and just trying stuff out. It won't break. Well, it won't break much. And you can fix it when it does, most of the time. But the best way to learn it is by getting and doing it. So I actually had the students do projects, and I had them do 4 projects over the course of the summer. There's my TIE fighter, by the way. That's the 4 projects that I had them do. I had them do a timekeeping and billing project. I had them do an advanced word processing project. I had them do some document assembly, and I had them do some web page design, and that turned out to be really hard to read. The timekeeping and billing was sort of the most fun that I had, and probably the least fun that the students had, or maybe second to least fun. What I actually did was I was trying to force them to use the timekeeping and billing software. So I had them bill me during the semester. What we did was we set up the timekeeper. We set up every student as a timekeeper on time slips, was the program that we used. And I told them, you got to keep track of every minute that you spend on this class, whether it's in class, whether it's working on a project, whether it's reading stuff off the web. You got to keep track of your time, and you got to enter it weekly. You can't wait until the end of the semester to put all this stuff in, because you will have forgotten it, and then you'll be making it up, and that's a no-no. We won't let you do that. So I made them all into timekeepers, and they had to do this, and I ran a report every week and found out who was entering in how much time and how often they were getting in and doing it. And if they didn't do their time, it affected their grade. And I told them that from the beginning. And at the end of the semester, they had to present me with an invoice for all of their time. And in return, they collected a grade. That was what they got back. Okay. The automated word, the advanced word processing was, we had spent a couple of class sessions going through some of the maybe more esoteric features of both Word and WordPerfect to take them through some things that they might ultimately have to learn, and then they had to actually implement those in a couple of documents. I gave them the documents so that they didn't have to type a bunch of stuff, but they did have to go back through and do a lot of formatting and features and tables of contents and things like that. So we got them to do that. That was one of the prep things that I had to do ahead of time, was to come up with some documents to give them that would allow them to demonstrate the sort of things that I wanted them to be able to do. Same thing with doing the document assembly program. After I used Hot Docs for that, and after walking through the Hot Docs tutorial with them and showing them what the features were and how they worked, I gave them a Microsoft Word document, a partnership agreement, and I said, I want you to automate this document using Hot Docs. Here are the features that I want to see in what you turn in. I want you to do this, 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 and this, and turn that file back into me, and you'll get graded on how well you implemented the features that I asked you to do, what extra stuff you thought would work that you threw in that actually did work well, and how well the finished product looked, and how professional this came out to be. So we did that. And then the last thing we had to do was I actually had them design a web page. I created a fictional law firm. I gave them some information about the lawyers in the firm, provided them with some pictures and some real short bios, and I said, go to it. Give me something creative. We picked a state. I picked a state, and I said, you have to find and follow the lawyer advertising ethical guidelines in that particular state. But within those guidelines, I just want you to take this information that I've got. If you want to put your own picture on it, your friends, if you want to make up some new stuff, that's great. Go to it. Have a good time. The students loved that part of the class. That was the favorite part of the class among everybody. And as a matter of fact, my one guy who had a real problem getting up to speed on the computer was so proud of having completed his web page. And we posted the web pages on our server, on the school server. But he then went home and got his wife and took her to the local library, which was the only place that he had access to the internet outside of the school, so he could show his wife the picture that he had, the web page that he made. Yeah.
Did you use the software program on shelf?
Yeah, we did. My whole purpose in a lot of this stuff was to be as off the shelf as I could. Because my thought was that we've got guys who are going to go out and do solo practice, and what are they going to do? They're going to go to CompUSA and buy a copy of Office, and or buy a copy of whatever, and that's what they're going to do. So yeah, we did that, and actually for the web page design stuff, I gave them their choice. I said, you guys, whatever you want to use. I said, if you want to, go out and get hot dog, or you want to go out and get some, something advanced, Dreamweaver or whatever, that's great. If you want to use MS Word and, export it to HTML, that's fine. If you make it look nice, if you want to use Netscape Composer, that's fine too. Whatever it was they wanted to do. Hopefully they got enough background ahead of time so they would sort of know what it was that they were doing. The assignments for each one of these are out on that web page that I showed you. I've got links to these here, but they give some examples of some of the things that I had the students do. All right. projects were fairly successful, but there was a lot of frustration because of the software itself. Right? That is a real pitfall in this. The preparation of the assignments took some time to do. I was a little bit worried about doing multiple projects as to how time-consuming it was going to be. The grading really was not that burdensome, in part because I had a very small class size, in part because I think I did okay in doing the design of the project, so I could be very focused on here are the X number of things that I think I'm going to be able to get out, so I could do checklists and stuff to grade them off against. What I found was the students tended to score highly overall, which was a little bit of a problem. There was not much differentiation between the students. They all worked at it until they got really good product. Okay, now there was some variation in the product. I mentioned that in a later slide, but I think a lot of the variation in what I got back was basically due to variation in their experience level when they were coming into it. But overall, they did just fine. And like I said, the web page design was the most popular. Now, the other thing that helped with the grading was I had some of the projects, not all of them, but I had some of them done as team projects. My purpose in doing that was, hey, I'm trying to duplicate some things in practice, and I'm trying to teach them something about practice, and most lawyers work with other lawyers, okay? So they need to get used to doing that. It minimized the number of projects to be graded. The student response was really mixed on that. Some of the students thought it was fantastic that they got to work with other folks, and they felt like it was a really good creative experience for them. Some of them got stuck with bad partners, and they didn't like it. And I think that was really the deciding factor, was whether or not they got with somebody who they could work well with. But again, that was sort of part of life. Resources needed. Okay, first you got to have sufficient computers for the students. Okay, that may or may not be a problem. Again, we taught this in a lab, so I had them use our biggest lab for doing this. You got to have the software to do all these things. Now, here's the good news. If you're thinking about doing this, the software can be free. Okay? All you have to do is ask. This is along the Lexis and Westlaw model. Okay? I called the guys up at Time Slips. I said, look, I'm teaching a class about using computers. I'm teaching a bunch of law students about what they will be doing in practice. Why don't you give me a free license to 20 copies, 20 user license for your software so that I can teach these students how to use your billing software, and that's what they'll be comfortable with, and that's what they'll be looking for. And the vendors were delighted to do that. They really were. So we got all the software. We didn't want to pay anything extra for any of the stuff that we had. Now, we already had Word and WordPerfect, and actually we already had Hot Docs as well, because we've been teaching that some in the advanced drafting classes. But it was not difficult to get the software. The hard part about it, though, was that we did have to install it and configure it on all those computers in the lab, which was a bit of a pain for our guys, particularly because some of the software is just not easy to deal with. There's some bad software out there, and I'll talk about that in a minute.
Did you get a network license or something?
Yeah, we did, and we did on some of them. Yeah. And that was something that's individual vendor by vendor, depending on what they did.
Cohen has mentioned, I called the people at Time Slips with that same proposition about 2 or 3 months ago, and I called a couple of other law practice software companies. Everyone I spoke with, it never occurred to them that a law school would want to be doing this.
Yeah.
It required me to send them something in writing.
Oh, that's
why I was doing it. And all they would give me was like a 30-day CD-ROM, basically just a version that I could download from the internet anyway.
There's no institutional memory at these places, I guess. Which doesn't surprise me, given the experience that we had. Everybody we dealt with probably is no longer working here. I hope. Long stories, I'll tell you that offline later. You also need an LCD projector like this, or on top of a card or whatever, to do the demonstration. That was something that was very, very helpful, because the setup that I had in the lab, again, had 25 computers that were set up in the lab, had the students sitting at the computers, had the screen in front with the projector. Sometimes I had my laptop up on the podium and I was showing them how to do stuff. Sometimes when I wanted to be more free to move around the room, I got one of the students who was comfortable doing that to sit at a computer that was then hooked up to project up on the screen. And so the students who were sitting around the class both had a desktop in front of them that they could pull up and do the stuff on, and they got to see somebody else demonstrating, which was really helpful. One issue that we had, and I don't want to cut Larry off too much, one issue that we had was access to computers outside of class to get at it. The lab that we used, unfortunately, because of our setup, was in a room that you could only get access to it through the library, and the library in our summer hours was sometimes closed when the students wanted to get in there and get at it. And that turned out to be a bit of a problem. So make sure that the students have access outside of class to complete projects, because they will need it. They will need a fair amount of time to work on these things, and they'll need access to the computers that have the software on them that they need. And also, you need some type of reading materials for them to do that. Okay, results. What do we get? We got very strong student interest. I've had students pestering me since last summer to teach this course again. There was a lot, word got around very quickly that it was a fun course and that they learned a lot in it. The quality of work varied, like I said, but I think that depended a lot more on the experience level of the students as they came in. I had a few guys in there who were ringers, who worked for our computer services department, and they were looking for a couple of easy credits. And they knew a lot of this stuff, but most of them told me afterwards that they still learned some things as they were in there, so it was not a real waste of time for them. And then we did have the students who were on the real low end of the spectrum who really had trouble finding the on switch on the computers. And they tended to get a whole lot out of this. They tended to take a lot of time, of my time, to walk them through things, but that's okay. High student frustration with some of the software packages, and I'll tell about that in a second, and high demand for a repeat on that.
Help me, I want to help you. You want me help?
Okay. We also had some problems, okay? Software was a major problem. Time slips, to be honest, was a disaster. I picked time slips for the timekeeping and billing program because, as near as I could discern, now I had used it before in practice, and as near as I could discern, it was the most popular and most widely used timekeeping and billing software that's out there. The problem is time slips is trying to be everything to everybody. It has far, far, far too many features, most of which you can't turn off and can't find. And you can't find the stuff you want, can't turn off the stuff that you don't want. It's hard to install. It did not work very well. We had trouble getting through to their tech support guys. It was just a real problem. HotDocs was not far behind because it's just very finicky. It was very easy for the students to screw up their HotDocs files on things, so we spent a lot of time going back and trying to fix the files for them, or telling the students, no, I'm sorry, you messed that up, it can't be fixed. You're going to have to start over from scratch, and that happened quite a bit. Generally, and particularly as to the time slips, I found that the software was not forgiving enough for an academic environment, where you got a lot of users getting at it who were not real well trained to start off with. Time slips requires you to have a fairly high level of knowing what you're doing and quite a bit of restraint in not messing with stuff that you don't know what it is in order for you to keep from screwing it up. And unfortunately, neither one of those is true in an environment involving a lot of students. And we had some real problems with students going in and they delete everybody else's work. Okay, great. So we got to readjust all the security configurations. So we figured out how to do that, reset everybody's security so that they couldn't get access to other things. Oh, guess what? Now you can't write the database, so nobody can keep time. So we had to do a lot of stuff to try to reconfigure things. It was a problem. The other problem that I had was lack of a good course book that was out there for my concept of what I was going to do. And I'll talk about that a little bit more in a second. The other thing was I had a relatively short startup time. I had about 3 weeks to put this class together. So it was very compressed, and it was difficult to do, and absorbed me quite a while.
To infinity and beyond.
You know where that came from? Toy Story. Okay. Okay. Last summer, when I was looking for it, there really was not a single satisfactory course text that I liked. Okay. I needed something that was comprehensive, that gave a big picture, and that also was current. There were a few that were out there, but some of them had been written, like in the late 1980s. And so they didn't have anything on the internet. There was nothing in there. I'm getting close to eating on Larry's time, so I'll have to finish up. There is at least one recently updated book that's out on the subject, and I have to say this because my dean wrote it. Okay, Hank Parrott wrote this. It's How to Practice Law with Computers. It is a PLI book, which means that getting it for law school use as opposed to practitioner use is sort of interesting, but it's there. It may work. I recommend it with sort of a qualification. It's a little bit of an odd mix. It tends to be very technical on some subjects that you probably don't care to be technical about, or you don't care what your students know about it. They don't necessarily need to know a lot about transfer protocols and stuff. Okay. In some places it gets there. In some places even though it's a lot more current than some of the other stuff that I saw, it's not quite current enough, and it doesn't go into a lot of detail as to particular applications, which, since I wanted to do a lot of training as well as the global talking, was not all that helpful. But that's one possibility. In addition to that book, the ABA's Law Practice Management section has 22 different titles on their web page. There's the web page address. You should be able to read that a little bit better. Under technology in the law practice, and at least some of those may be helpful. Generally, these section publications are useful. I don't know that I'd want to use them as a textbook necessarily, but they may be really useful for you in developing stuff on the course and looking for subject matter. That's all one URL. The lawoffice.html is part of it as well. Also, there are materials available on the internet. In addition to my site that I gave you the URL to, what I found out is that at least for some of these things, there's a lot of information out there. Web page design is an example. When I was going out and pulling together the materials on HTML and web page design, the problem was screening them. There is so much material out on the web on how to do that. It was tough to find the best resources or good resources that were going to be useful to the students.
The server is now complete. When I left you, I was but the learner. Now I am the master.
Okay. Lessons that we learned in doing this. We're almost done here. First one is start well in advance. I could have used a lot more prep time than the 3 weeks that I had. One of the things in particular that would have been useful to have that time for would have been enough time to set up a practice management system. Okay, when I taught the course, I talked with the students about practice management systems, but I didn't have one that I could really demo for them because I didn't have the time to set it up. And that would have been a useful thing, I think. And that also would have gotten us around having to use time slips for our billing program, which also would have been useful, which was just what I just said. The other thing was, it would have been really nice to have had the software for a little while longer so that we could have run some stuff through it and tried to identify problems ahead of time. That would have been very useful with the time slip stuff. Using some type of course book, whether it's Hank's book or whether it's something else, one of the practice management section books would have been useful. The use of the materials on the web page alone got a little wearing on the students, and quite frankly, particularly as you got to the end of the semester, and I was struggling to keep up with getting stuff up there, and I was using a lot of hyperlink stuff, and they didn't really want to go through all the hyperlinks. They didn't get as much out of it as they could, so it would have been nice to have some more. And the other one was making sure the students have sufficient access to the computers outside of class, because that was a difficult thing for them. And remember, last quote. And it'll be Larry's turn. And I'll hang around during his session. We can answer questions after he's all done. computers time.
Hi, I'm Larry Cohen. I was at the University of Michigan until about a year ago, and then for a variety of reasons, I left to go back to private practice. I still affiliate with the university, but mostly what I'm doing these days is private practice. And I'm mostly a trial lawyer, so a lot of what you're going to hear are biases that I have from the perspective of being a trial lawyer. It's not working, so. But I'll tell you what. Seeing as I have 15 minutes, I think and since Tom's slides are just so wonderful, I think what I'm going to do is I'm just going to go through what I have and do it that way. So I'll see my lovely slides and you won't. Let me start out. I'm going to run through all this fairly quickly, obviously. Let me start out with what, both in my practice and in talking with other lawyers, are painful lessons of what happens when students come out of law school and start practice. The best illustration I can give you is a student who came out of law school, went to work for the courts, and in 1 week used up the court's entire annual budget for Westlaw. Another painful lesson is the one I call the computer ate my homework, where you have an appellate brief due on such and such a date, and you have to call the court and say, gee, I need more time, the system crashed, or I've lost my file, or there was a virus or something, can I please have more time? That happens with a great deal of regularity, and courts are varying levels of enthusiasm to help you out. For example, in my jurisdiction, they won't. You get a stipulation or the court's going to say, sorry, it's just too late. Speaks to the importance of backup. We do not speak your language. You have a file that you want to send over to a client, or you want to, in the electronic filing days, send down to the court or something. Turns out that their language doesn't work with yours, so they can't download it. I can't tell you the number of times that I have sent things off as an attachment. They try and open it up and they can't. They don't get back to me right away, or I go out of town. Days go by and all of a sudden this client is out looking for another law firm, another attorney. No, you can't have it back. This is when you send something to the wrong place. And that's not a problem until it gets into attorney-client issues. You send your client a letter explaining how you're going to get the other lawyer or do something with the other lawyer, and it turns out it went to the other lawyer. Now, I've done that mostly by fax when it's happened to me, but I've talked with lawyers where it's happened by email as well. I'm not quite sure how it's happened, but it's happened. And it can create rather dramatic problems. You get whole arguments about, well, ethically, what am I supposed to do? Do I have to give it back to you? Or, gee, this is pretty interesting stuff. I'll give it back, and I promise to forget what was in it. Then within the law firm, you want to do what? You come out of law school with these wonderful ideas about all these things you can do, these great things you've heard about, these great things you've seen, this wonderful class you've taken. Only the people who run the law firm have absolutely no interest in spending money on your doing it. And sure, once you get your 3,000 billable hour, then you're welcome to spend whatever you'd like to do working on that. And so that becomes a practical problem. And then finally, one of my favorites, you have the right to remain silent. That's when you get crosswise with somebody else's copyright. Which can happen with respect to forms. And in fact, form practice, I think, is considerably more extensive now than Tom was suggesting to you, and so it can become an issue when you use somebody else's form. Things that are in the public domain, things that are filed, are not so much of a problem. When you start using things that are not in the public domain that you've gotten from someone else, you can run into some problems. So these are all painful lessons about applying technology that I think have implications back to what we should be doing in law school, teaching students. A lot of what I want to talk about now, I've sort of prepared to talk about in the context of what I would or would recommend that you put in a course, a single course. But I think these are things that you can incorporate into everything that's done in the law school, any kind of technology-related course, whether it's one-on-one with a student or through the legal writing program or incorporated in substantive courses, although I can see that doctrinal faculty are not terribly enthusiastic to hear about things that we think that they should put in their classes. But I think putting them into doctrinal courses can be really useful as well. Issues in practice. What is it that's out there that makes it difficult very often to go from the wonderful things that we've talked about at this program and last year's program into practice? The biggest one, frankly, is technophobia. One of the things that I do is I wander around the country teaching continuing education programs. I teach about 100 a year all over the country. And the thing that I see more often than anything else is when I start talking about things like using the internet, dealing with real-time reporting by court reporters, and I'll talk about that in a couple of minutes. Getting information out of databases at the library. I mean, lawyers look back at me with just blank stares. I mean, I come in with offers to hand out all kinds of lists of things, websites, giveaway software, everything else, and hardly anybody comes up. hardly anybody comes up, maybe 5-10%, because they are just scared to death of using this stuff. Another issue is fear. Not fear in the sense of I don't know how to use it, but fear in the sense that something's going to happen when I try and use it, and I'm going to be ruined. Like I'll start using word processing, in terms of me drafting documents instead of dictating and things like that, and it's going to crash on me. Or I'll use some technology in the courtroom, and it won't work. Like my computer, for example, has crashed 10 times in the last hour. And so I'm waiting for it to crash again. And my fear is that if I rely upon this when I get out of the courthouse, what's going to happen when I get down there and I'm in the middle of a trial or in the middle of a hearing and it crashes? Or I take it to a meeting for negotiation or for contract work. I'm just terribly, terribly fearful that things are not going to work out. So it's fear of failure and fear of embarrassment. We can all talk about what law students are like, but the principal characteristic of a lawyer in practice is someone who is scared to death of being embarrassed in front of anybody else. And technology provides an opportunity to do that because they don't really know what's going to happen with it. Another issue in practice is availability of resources. People who go into the larger firms are likely to be in places where resources are relatively plentiful. But people, not just in solo practice, but in medium-sized firms. I practice in firms I'm currently a solo practitioner. Before that, I had a firm of 10 lawyers. Before that, I was with a firm of 70 lawyers. And all of those firms, issues of availability of resources have been a real significant issue. Keeping up with technology, should we buy the new trial software? How are we going to go about with electronic filing? What do we need to bring in-house? And $6,000, $10,000, $15,000 can be a dear amount of money, particularly to a solo practitioner. So there's a real variability and availability of resources. And you know who your students are and where they're likely to go. There's a problem with compatibility that I talked about before with the story in terms of incompatibility with you and your client. There can be incompatibility within the law firm. Very often these law firms have become technologically sophisticated, but only by going out and buying things on a catch-as-catch-can basis. If you have a 50-person law firm, but you may have 20 different kinds of software and hardware applications around the firm, and so dealing with incompatibility can be an issue. And certainly with clients. Technical support. Most of you, or many of you, are technical support people, so you might not think about it very much, but when you get out in practice, technical support is a real problem. We have time slips. I hate it. I absolutely hate time slips, because no matter what your problem is, there is no time slips available to help you. It's not there. We tried to get I finally hired someone and when I put my ad out, the top of the ad was, can you do time slips? Or words to that effect. I wanted someone to do time slips because it's so hard to work with, because it's very limited technical support, particularly in the small and medium-sized firms. There's uncertainty as to rights, a lot of issues about what rights you have to material on the internet. Confidentiality issues are a very, very big deal. I attended the privacy talk yesterday, and I would like to think that I'm at least somewhat sophisticated technologically. I'm usually viewed that way wherever I go, but I know that I'm not. Whoever was giving the talk yesterday could have been talking Latin. It was just all over my head. I had no idea what he was talking about. I know privacy is terribly, terribly important. There's a big issue by using email, for example, with clients. If I send a client an email message and it's not encrypted, have I violated the attorney-client privilege? Because that's now accessible, theoretically, on the internet. So there's a huge issue of privacy about exchanging information electronically. Time is precious to lawyers. Time is very precious to lawyers in practice. We always joke about billable hours, but when you're out in practice, it's not a joke. There's only a certain amount of time available to do all the things that you want. And the more time I have to spend as a lawyer dealing with technological problems, the greater the impact it has on my ability to earn a living. Now, the other side of that, of course, is once I get technologically proficient, I can save a lot of time. But teaching people and making people understand that trade-off and what it's worth to get there, I think, is at the very heart of talking about applications of technology in practice. Notwithstanding all of that, lawyers are going to be, and increasingly are, being dragged kicking and screaming into the technology age. And it's funny to talk about that to a group like this, and this is the third one of these conferences I attended, but for lawyers in practice, it really is very much thinking about coming into the technology age, because for most lawyers, if they do word processing, they are really pretty advanced. So that is the reality of what's going on, again, in most firms. Form practice is just essential. Form practice, not in the sense that a lot of practices can be done on a form basis, but form practice in the sense that it can be tremendously time-saving. And while it may be that larger firms, when they create form databases, don't share it very well, individual lawyers do use forms on a very, very consistent basis. They build up their own form books, and having it on a computer can be tremendous time-saving. And so, when lawyers begin to appreciate the value of that and can see the value of that, then it becomes very much part of what they do. Electronic filing is currently the wave of the future, and there's many, many projects around the country right now. I attended a program in San Diego the day before yesterday, in which there was a whole session devoted to electronic filing. Courts are increasingly going to require attorneys to file things electronically, and it's going to turn out to be much more efficient for lawyers to do it that way. Independent contractors are increasingly using technology. For depositions, for example, I gave a 3-hour seminar on Thursday on deposition practice to about 200 lawyers, and the thing they were most interested in was the fact that as the lawyer is taking the deposition, the lawyer can see the language on the screen because of what's called real-time reporting, and can basically monitor the deposition as it's going on. The deposition transcript can be emailed the day of the deposition to the lawyer. The lawyer can have the transcript immediately for continuing discovery, for motion practice, things like that. And so that's an advantage that's available from independent contractors, and there are like advantages available from expert witnesses and all kinds of other folks that lawyers are going to have to do to stay up with one another. Technologically advanced courtroom. I just finished a 2.5-week trial involving, I represented a battered woman in a case, and there were two sets of issues that came up that were really pretty interesting in that case from a technological standpoint. The first one is there were no court reporters in the courtroom. Everything was electronic. And in one of the federal courts in the jurisdiction I practice, there is a court reporter, and as she types it into her machine, it comes up on the screen, so you can see the testimony as it's coming in. And being able to take advantage of that as a lawyer, having your own resources is important. The O.J. Simpson trial is a good illustration of the technological advances in trial practice these days, with all the technology there and the organizational materials. There were hundreds of thousands of documents, or pages of documents in that case, all of which was done electronically. The Exxon Valdez trial was all done electronically. The other technological issue that was interesting in that case, and this I thought of yesterday when I attended the seminar, or I guess the workshop. The biggest issue in the case that I just tried was this. The number one piece of evidence that we had that this guy had really been beating her up was that on the last time he beat her up, she went to use the phone to call 911. She dialed it, and he pulled it off the wall. As it turned out, however, it didn't disconnect the line until the entire assault was on tape. The problem we had was that the tape was terrible. And so the issue for us was whether technologically we could do things to enhance the quality of the tape without changing the substantive information. And that turned out to be an issue not of setting it down and having someone work, in terms of machines, but giving it to someone to see if digitally they could work with this tape to try and improve the quality of what was there. And then it became an issue from an evidentiary standpoint of what did we change. All of that's technology that goes beyond word processing and into the everyday realities of practice, and it had a tremendous impact in the way that case turned out. The jury said they listened to the tape over and over and over again in trying to decide what they did. Trial presentation materials, I mentioned the O.J. Simpson trial. Dictation software. Tom mentioned lawyers don't like to think they're going to sit in their office and type. Well, there's dictation software available now. We can simply talk into the computer and it all comes out. And again, lawyers coming out of law school need to be aware of this, and it turns out that to be relatively inexpensive. Let me jump ahead to the kind of things that I think might be put into a class or a series of classes to try and make this work. The first thing I think is important to talk about in these courses is alternative databases. Westlaw and Lexis are wonderful. I'm not here to in any way say anything negative about Westlaw and Lexis. But the reality is they're very expensive. And while they've tried to come up with pricing methods that are very useful, there are other things that many lawyers, as a practical matter, have to deal with. I was with a law firm that broke up about 5 years ago. We paid off every single debt. We took care of everything. I mean, we had a huge amount of money coming through the firm, but we had huge debt because two of my partners were using the firm as a personal checking account. So we had lots of debt, but we were able to take care of everything. You know what the one debt we couldn't take care of? Westlaw. We had $150,000 Westlaw bill sitting out there that we couldn't deal with. And all they ever used it for was case searching. They didn't use it for anything else. So while Westlaw and Lexis are great, I think it's prudent for law schools to be teaching about alternative databases like Versus, which, as you saw from the pricing out there, is available for $7 a month. That's just part of the reality for lawyers. And yet, if you ask lawyers what is Versus, they would say, well, it's the thing in between, plaintiff versus so-and-so. That would be as far as they can go with Versus. And fine law may turn out to be essential to lawyers in terms of having access to other kinds of information. So I think these courses need to talk about alternative databases, or I think we need to do that in the law school setting. We also need to talk about alternative sources of information. And I know there are many people here who are involved in library work, and whether they're directors of libraries or directors of research or whatever. The thing that I talk to lawyers about all the time is places they can go to get access to alternative databases. County law libraries are increasingly getting resources. For example, in my community, Westlaw is available at the county law library. Not in the entire Westlaw database, but a lot of it. And knowing enough to get out and look. And if when I teach seminars, the lawyers are astounded. What do you mean it's available? I mean, I've been teaching that, for 2 years now, and I still run into loads and loads of lawyers who have no idea that they don't even think about it. Academic libraries are a tremendous resource for getting information, not necessarily about the law, but about the things we as lawyers deal with. Very often we as lawyers think in law school, only about teaching the law. And yet what we do as lawyers in practice is use the law to do other things, get into other areas. And lawyers need to understand that there's electronically available information in a wide variety of sources. Other firms' libraries are likewise something that lawyers just need to think about in terms of places to go for information. I'm sure there are other places out there, the internet, and places that you know about and I don't, that I'd be embarrassed to say that with everything I'm doing, I still haven't run into. Another set of issues I think that need to be addressed in these courses are dealing with the consumers. And by consumers, I mean the courts, clients, and other lawyers. These are all consumers of what lawyers do, and lawyers need to think about the technological connections, and maybe to the extent that transfer is an issue of the text that Tom was talking about, that maybe that's part of what needs to be done electronically. But I think lawyers, from a technological standpoint, need to think about how, for lack of a better term, they interface with these other consumers, for lack of a better term. Privacy issues. There has to be some discussion about privacy issues. That is becoming. You talk about things that get lawyers in jail. The thing that I hear about it, the thing that lawyers that I know remember is not so much you can't testify at trial. Sadly, there are a lot who don't seem to remember that. But rather money issues. All lawyers know that you're not supposed to steal the client's money. And that seems to be the one thing they all know. But increasingly, the one thing they're all going to know is attorney-client. Because lawyers, there are two things lawyers do. They use word processing and they use email. But they don't think about the email. They don't think about encryption. And increasingly, there are going to be disciplinary actions, and lawyers get into huge trouble for not dealing with the privacy issues that arise out of their communications with their clients electronically or communication with other lawyers. And I think intellectual property issues are something that have to be talked about in these courses, even if only to say, hey, there are intellectual property issues out there in terms of the things that we use. Dealing with the uninitiated. Lawyers need to learn how to communicate with people who are not technologically advanced, because even as we as lawyers get more technologically advanced, our clients are not. And by clients, I don't just mean individuals, I mean institutions as well. There are loads and loads of institutions that are just not very advanced electronically, and learning how to deal with them and interact with them as we become more technologically advanced is extremely important. Building support networks, as I said, support is very, very checkered in terms of its availability in private practice. Come out of law school having had the opportunity to work, and I hear all the tech support people saying how burdened they are, but you're wonderful. You are just great folks to have there and have available, but you get out in the real world and there's nobody available anymore. Mom and dad aren't there to take care of me anymore, which is how you are often seen when it comes to these kinds of issues. So talking with lawyers about where to go for help and how to build support networks. If you're going to teach them the technology, you can't just send them out and say, all right, you got all this technology. You got to tell them how to get help dealing with it. Lawyers need some understanding about how to evaluate new technology. This conference is a testament. Every year you come here and things have taken the next step within a 1 year time. So when you send lawyers out in the practice and say, be technologically sophisticated and do all these things, you also need to give them some sense of how to go about assessing what they should be looking for with development in the future. Do I really need to move up to the next level? Do I really need that new hardware? Do I really need that new software? Can I get by for a while on what I have? Next issue, and again, I'll be done in 2 minutes. I know I've run over and I apologize. Budgeting. Law schools, budgets are always an issue, but the students never see that. All the students ever see is we get this stuff and you're around and you hear, you do it, we don't have to worry about it. But when you're out in the real world, charging out expenses. If you're going to be going out and buying and using this technology, what can you do to build it out? For example, the trial presentation technology that you saw in the O.J. Simpson trial cost about $20,000 to buy. When you get it, what do you do? I mean, do you charge the client for the case you're in? Do you spread it out over cases? Issues about what lawyers need to do from a business standpoint in dealing with this technology is extremely important, because if they can't do something with it from a business standpoint, they may as well not have it, because they can't afford to absorb it, particularly in smaller practices. And that's it. Thank you.